Right, so this is actually part 6 of the criminal procedure rules. This is the 2020 rules. So this is on reporting restrictions. It actually says etc. It says reporting etc. restrictions. Well, the newspaper might try to put a restriction down on you or on us, right? Have you thought of that? It just says restrictions, reporting, etc., and restrictions. Well, the court usually is attributed to the party who applies a restriction, right? But it just says part 6, reporting, etc., and restrictions. Well, who's reporting? Depends who's reporting it. The court might need to report something. The police might need to report something. The police might need to ask for witnesses to come forward. The Crown prosecution might need to. The claimant might need to, right? Well, what if the newspaper decides to put their own restriction on it? Well, that's relevant because that is a reporting restriction. If I wish to report to the public that I've got a petition and I want them to sign it, then I am the reporter and I am going to make use of the newspaper's services, right? Now, if the newspapers decide they're going to refuse to publish it, they are placing a restriction on me, okay? See the word? Restrictions, right? Reporting, etc., and restrictions, right? We're on the right subject then, aren't we? Are we on the right subject? We're talking about persons who wish to report things and any restrictions which may be imposed by a party, right? We haven't got to who that party may or may not be yet, right? Because it just says it's concerning reporting things and any restrictions. Any restrictions, right? Could be a restriction imposed by a newspaper themselves on their own newspaper or on a client. Now here, right, contents in this part, general rules when this part applies, court power to vary requirements. It says vary requirements. Look, court's power to vary requirements. Well, what will the requirements be? The requirements might be that you wish to remove the restriction that the newspaper has placed on the client, on the person publishing, right? Reporting and access restrictions. Well, that's what it is. If I want to publish a petition in a newspaper, right, and I'm trying to report to the public that I've got a petition, I might have some access restriction problems because they might not be wanting to put it in there, right? Varying or removing a restriction, right? Well, that's what I want to do. I need to remove the restriction that the Daily Mirror has put on me, and also they're refusing to reply to emails and just blanking me, right? Representations in response, order about restriction or private trial, sound recording, blah, 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 right? When this part applies, right, we're just loosely interpreting this now. This is the criminal procedure rules, not civil, but as I will explain in a minute, all this can't apply to Parliament anyway because, well, look here, look. When this part applies, well, this is just like a theory, right? I'm just putting some theory out to think about. This part applies when the court can impose a restriction on. So this is when the court can, right? What about when the newspaper can, or can it? Reporting what takes place at a public hearing. Notice they call it public hearing. This is really important words that they've got. Because although this is the 2020 criminal procedure rules, right, this wording has been used in the criminal procedure rules for a long time. Notice it does not say reporting what takes place at a trial. Does not say that, does it? Does not say reporting what takes place at a trial. Does it say reporting what takes place at a hearing. It just says public hearing, right? Now, would you define, let's say we're in the middle of Market Harborough, right? We're in the middle of Market Harborough, right? And we're walking around the town centre and we're going to some shops, right? Oh, there's a bell ringing, ding-a-ling-a-ling, ding-a-ling-a-ling. Oyez, oyez, hear ye, hear ye. The mayor has announced that anyone found in the streets selling newspapers without a license will be arrested on sight. Hear ye, hear ye. Right. Is that a public hearing? Is that a public hearing? I got a notice board, right? And I put something on it. Public notice board. Is that a public hearing? Yes or no? Right? Reporting what takes place at a public hearing. Public access to what otherwise would be a public hearing. Well, public access to what otherwise would be a public hearing. Right, well, what about, let's see. Public access to what otherwise would be a public hearing. Then how about the Public Meeting Act? Oh, it's called the Public Meeting Act, right? Public hearing. If we use the Public Meeting Act and we're having a meeting in public and it's illegal to remove someone from there or prevent them from transacting information, right? Then public access to what otherwise would be a public hearing. Well, if you're having a public meeting in public with the community and not allowed to be removed from it or prevented from transacting information, is that a public hearing? Are the public hearing a meeting in public? And could the newspaper publisher walk around and tell those people that they're not allowed to transact information in that public meeting? Could the newspaper reporter who's walking around with his notepad and pen remove someone from that public meeting, and could he stop them from giving evidence in that public meeting in the town centre? No. Why? Because it's illegal, right? So the newspaper owner and the newspaper reporter and the newspaper staff cannot prevent any persons from transacting information or attending a public meeting, right? That's somewhere to start with. To publish means to make available to the public or a section of the public in whatever form and whatever means. Well, if you're wanting to meet with the public using a newspaper and publishing it through any form and any means, then surely that's a little bit like having a meeting with the public through the newspaper. So can they prevent you from transacting the information? Well, only if you're breaking the law. If you're breaking a law, is it legal? Well, if it's privilege of Parliament, you can't break the law because you can't be prosecuted through a court by civil or criminal proceedings. So you can't be prosecuted. So you can't be breaking the law. That's why you get a certificate from the Speaker of Parliament. So the newspaper can't say, oh, we can't publish this because it's illegal, right? Therefore, how are they going to stop you publishing it if it's lawful? Because they can't say that, oh, that is what you're doing is illegal, right? And also, if you are meeting with the public and sharing something by any form and any means, then, they can't stop you transacting information, surely, right? That's somewhere to start with. Vary or remove reporting access restriction that is imposed by legislation, right? Well, the law imposes things by legislation if it's illegal, if it's defamatory, or if it's harassment or whatsoever, but not with a certificate from the Speaker of Parliament. So they can't impose by legislation if you're privileged. So there's no restriction through legislation, So who else is going to impose a restriction? The newspaper owner, just through ownership, because he can do what the hell he wants because it's his newspaper. But what are you using a newspaper for? To meet with members of the public to transact information, right? Well, if you're not breaking the law, then there's no reason for him to refuse it, surely, because there won't be a legal restriction in place. So it's his own personal restriction. Yeah, can that man... we're getting into employment. I can see we're getting into the area of unions now, a little bit like unions walking around the factory handing flyers out and their employees saying, "Don't hand that flyer out" or "Don't put that flyer up" and stuff like that. We're getting into that area now, and it's not going to be. It's going to be messy for the newspapers because since 1985. They've become completely and utterly mainly the price people out of being able to put notices in there, and then we're being taxed and not getting tax relief. We've been paying taxes for newspaper adverts when it's not for profit. So they've been taking taxes from us to also prices out the newspaper. When Boris Johnson gets a nice little column providing entertainment, while he's still running for government. The London Evening Standard hasn't... Well, they've tried to... I've always won legal arguments with the London Evening Standard. The Sun newspaper and Daily Mail are quite expensive, but I haven't actually specifically been rejected by them. But... This Trinity Media Press company is starting to be a pain because they're just starting to blank emails and ignore them. So their night lawyers need to get a new suit of armour because they've been giving ill advice and wrong advice out because they don't really understand the law. They don't understand what the actual law is really when it comes to things like the dynamic of the Public Meeting Act and this legislation here. And anything that is illegal or unlawful, but if it's not illegal or unlawful, there is no there's nothing that can be imposed by legislation, right? What can it be imposed by? You see, the newspaper owner might think that if he's in a town centre and people are having a meeting and they're having a meeting about his newspaper being shit, right, that he might be able to stop them from speaking, but he can't. Order a trial in private or... Well, that's a little bit like the 1960 Meeting Act because a certain authority can decide not to have the public present, but if it does, then it's privileged. Allow there to take place during a hearing, sound recording and communication. Measures to assist a witness or defendant to give evidence. Right, well, if you are putting a witness appeal in a newspaper, you're actually assisting a witness. You are not just assisting them, you're facilitating it, because if you can't contact and communicate with potential witnesses to come forward, they can't give evidence, right? Because you can't locate and find them where they are, right? And you need to understand this, right? So you're assisting a witness. You are assisting a witness, right, to give evidence when they see a notice in a newspaper asking for them to come forward. Now, this is interesting for Parliament and petitions to the House of Commons, because here it says, look, no, the court can impose reporting restrictions under all these acts, right? But they can't, the court, a magistrate or Crown Court can't impose any restrictions at all whatsoever under any of these acts, because when it's a House of Commons petition, the court can't hear it. The court can't hear the case, the trial, like Lord Hanningfield, right? So that is, all these are immediately void. like after these Contempt of Court Act, criminal procedure investigations. Well, that one's got that's legally privileged items and information, which a petition to the House of Commons in the newspaper is a legally privileged item and information as well, which cannot be used. That it itself, the newspaper couldn't. The newspaper can't go to court to challenge you that you can't have it in their newspaper because they can't use it as evidence because it's legally privileged, right? So, if the newspaper went to court and said, like, I'm going to prove in this court that I can stop you from putting this in my newspaper, he can't, because he can't use the advert as evidence, right? Now, if he just refuses to publish it and it doesn't go to court, if you take him to court to prove that you can put in his newspaper, right, he can't use your advert as evidence, right? But the court can't hear it anyway, because the court can't hear matters of parliament. The court can't hear the case, right? Because it's a matter of parliament. This is why you can't be held to any commitments. It's a little bit like, you see, all this is like written off all these acts here: judicial proceedings, contempt of court, blah blah blah. So, to allow information, for example, a name or address, to be withheld from the public at a public hearing. So this word now is really a public hearing, right? So when you actually put something in the public notice section of the newspaper, right, it's for a public hearing. What you're actually doing is you're putting it there to be publicly heard. It's a public hearing facilitated by the newspaper in the notices section, right? So the newspaper is actually facilitating public hearing. Now, this is the thing. So with the newspaper, although it might, the news, you have to understand the newspaper when it comes to public notices section really a little bit like a bus station, right? It might be owned privately, but people go there to get on buses, right? That's what it's there for. Now, what happens if they say, you smell, get out of my bus station, right? I don't like the smell of you, or something like that. You could probably sue them under discrimination laws, discriminating against you or something like that. Maybe they might prove that you shouldn't be in there, but if you prove that there's nothing wrong with you, why would if you're not breaking the law, if you're not unhealthy, if you actually is nothing unlawful that you've done, then how could they possibly win the case? Even if they tried, obviously you'll be likely to win. Or they could just say, because then you start bringing in discrimination and all this type of stuff, which we've got in England, like, oh no, I'm Chinese, or I'm a Buddhist or something like that. Then the newspaper can't just say, oh yeah, don't fancy having that guy in my bus station, right? So this is the thing with the newspaper. The newspaper's out of its depth with all this array of legislation, but the thing is, it can't be heard in the court, right? So at the moment, what the newspapers are doing, they're just running on pure yellow Dutch courage and just like muscling it and just saying, we can do what the fuck we want, right? But if you get that, newspaper chief executive out in the street, right, with his, big, muscles and his, his white shirt, and he's like, when he bends his arm, his shirt rips because his, muscles are that big on his arms, Chief Commissioner Gordon or something or whatever, the thing is, right, when he's in work, right, he's the boss, right, so he can say, you're sacked, or he can, send you home or whatever, or obviously we've got employment law, but, he's the boss, like Bezos, sweep the floor, go bring me 1,500 boxes of widgets, right? I'm the boss, I want you to paint the walls green, right? Now I want you to go make me a cup of tea, right? I'm the boss, right? It tells people what to do. But that same guy, right, walks out into the street, people are just gathered together and start having a meeting, and then that guy goes, oh, I don't like the way this meeting's going, right? You all shut up, and said, like, who the fuck are you? These are our streets, these are the public streets, right? So, what's the situation in the bus station? If people are not breaking the law, they're in a bus station, and then 20 people gather around, and they decide to start talking about, maybe they might want to say, maybe we should put a complaint in about this bus station, right? We don't like it, and the bus station owner comes, but they're not breaking any law of England, right? And if he says, right, get out of my bus station, right? But you're not breaking the law, on what grounds? Well, I don't want you here. Well, I'm catching the bus, Now, the thing is, that's the thing. It's a similar kind of situation because you are in public. It's a public place, and you might be having a public hearing because you might be having a meeting in public, right? Now, this is the thing. This is when all the law comes into effect. Now. So here you see you've got this area of law for local council authorities, which is what are the publicity requirements for traffic regulation orders, okay? In making a traffic regulation order, TRO, local authorities must follow the regulations, which include provisions relating to publicity, requiring publishing the notice in a local newspaper, right? Making the orders available for public inspection at council's offices, which are likely to be close to the public during the time, and where considered appropriate, posting the notices on the streets, in recognition of the potential difficulties in complying with the public requirements. The Department of Transport has guidance how a council may still publicise a TRO. The guidance recognises not everyone may be able to access local newspapers. So basically what it's saying is, right, it does have to go in the newspaper, okay? Legally, the newspaper can't turn it down because there's acts of law saying that it has to be put in a newspaper, right? What if the newspapers say that they're not going to put it? Well, the council will take the newspaper to court. It likely doesn't happen because the newspaper wouldn't dare to say, no, we're not publishing it, right? Why? Because then the council would just take them to the magistrates' court and they would enforce that act. So the magistrates' court would be making an order for a newspaper to publish something because it's doing something which it's legally obliged to do, right? But it's saying that not everyone will be able to have access to the newspaper, okay? Not everyone can get hold of a newspaper, and not all newspapers are online, so it has to do additional things as well. Here it says, local press roadwork notice spend. Response to a request regarding the annual spend on press notices relating to warnings of road closures. Someone asked for this information. I actually thought they might have got them for free. I actually kind of thought that they might have had to give them free advertisements, like free ads, but apparently they pay for them. Hold on a minute. So here's a letter, a Freedom of Information letter. Thank you for your Freedom of Information request, etc. In your email, you asked the following. Please, could you tell me how much you spend annually on notices in the local press? Giving warnings of road closures or roadworks, etc. So they're saying that for the last financial year, from April 2016 to 2017, on to March 2017, we spent just under £1,350. Is that, or is that like £1.30? No, it's not £1.35. It's actually £1,350. Is that? Oh, million? What? Million? We spent 1.35 million nationally on traffic regulation orders, both temporary and permanent. Is that for like all local councils and the government? Is that for like all England? Is this for like every single local authority in the whole of England that falls under the Department of Transport? I don't know. Or is this just for like, because really, I don't think traffic regulation orders are used as much by the highways agency as much as like the local councils, because they've only got trunk roads, haven't they? If that's only for trunk roads, 1.3 million. So the newspapers are making 1.3 million out of required business. They're not going to turn it down. So that's quite a lot of money. Don't know what it adds up to with the local councils as well. They wouldn't dare say we're not going to put it in there. And also, what are they losing money? But you see, this is the problem, right? So up until that Parliamentary Papers Act and this whole kind of like Hansard, right? No one had actually ever challenged Parliament in anything that they published. No one had even thought, and no one had like challenged newspaper adverts, because people weren't getting newspaper adverts until they got court consent. So if you got court consent, then the newspaper's not likely going to challenge it anyway, right? But so no one had done it, but they actually had a go at it. Now this is the thing, right? Has a newspaper ever said to a local council, "Oh, we're not going to publish that traffic regulation order," "Oh, we're not going to do it"? And then, no, the newspaper, what we're going to do about it? Well, actually, you'll find that it's legally required for them to do it. So what the council would actually get them, like if you get a parking ticket, you don't pay it, then they send you a summons to magistrates court. So what they do to the newspaper, although most of the local newspapers are right up the local council's backside, aren't they? They're like best buddies. They're like peas in a pod. They're like, party pals. They're like, Butch Cassidy and the Sundance Kid, But if the newspaper was to say, "Oh, we're not publishing it," then you'd find the council would be like, "What? You what? We're not publishing it." Like, then the council would be like, "Just a minute, you got to publish it." And then they'd be getting the law out, and then they'd get the magistrates court, like they do with people who don't pay the council tax, or, who haven't paid a parking ticket or whatever, get them to the, magistrates court. And the newspaper actually would be going to the magistrates court, right? And they get the act out, that says that, traffic regulation orders shall be published in at least one newspaper, right? And the newspaper, someone from the newspaper would be there. I don't know whether it would be the editor or whatever. I guess it would be the owner of the newspaper, like, just like, if if a vehicle's owned by a company, and you don't know who's driving it, they send it to the company, don't they? And then the owner has to, tell them who are driving, who's in control of the newspaper, who's refusing this advert, that's it. I don't think they haven't encountered it and they haven't encountered it because no one's, no newspaper is or has likely, dared to say we're not publishing it. But this is the thing with us; they are doing, we haven't got any, we haven't got any enforcement. This is the thing. The local council, if they did have the cheek to say we're not publishing that traffic regulation order in there, then the council would go straight to the magistrates court, and obviously it's our money, not using their own money to do it. It's like, it's the government. But when they're not publishing ours, this is probably when you could get public lawyer, but they're not even acknowledging our privileges, anyway. this is the type of thing that, public law should do, public lawyers, but really, Parliament should, back you up, because this is the thing. It's not meant to be. Parliament matters aren't meant to be heard in the magistrates' court or the county court, are they? So Parliament is the court. That's the thing. Parliament is the court. So they're meant to write a letter to the newspaper and say, why are you putting this petition in? This is the thing. But the problem is, Parliament aren't even wanting to put our petitions on their website if they can get away with it, unless we bend over backwards and write it out how they want us to write it. So they're not going to back us up in the newspaper. I mean, we're getting them on change.org and on 38 Degrees, but occasionally they'll get removed, right? And they're not helping us with enforcement of that. But other than that, they're sort of, 38 Degrees and change.org are generally quite relaxed and slack. Those websites aren't, forcing people to that many restrictions, although I've had some 38 degrees ones taken down, but only by sort of like bad luck, really, just because I got someone to do some advertising and they did a bad job of it, and it was just unlucky, mainly because I find it difficult to get any help sharing it, and they're not providing, good sponsorship options like, they are on petitions.net or change.org. 38 Degrees is it's partisan. It's a partisan run website. They pick and choose who they're going to help, unfairly with all the money that people are giving to it. Applications for reporting restrictions. Where the court has the power to impose a restriction on a reporting of events at a public hearing or on public access to an otherwise public hearing. Well, you are actually having a public hearing for a petition to Parliament because it's a messenger process and it's like a public meeting under the Public Meetings Act, and you can't have any civil charge against it through the normal courts. So it is a public hearing. Now, has the newspaper got the power to impose restrictions? That's interesting. Look, where the court has the power to impose a restriction. Well, what about if you phrase this like, where the newspaper has the power to impose a restriction? Has it got the power to impose a restriction or not? This is the thing. You see, what's interesting about this is that in the 1960 Public Meeting Act with local authorities, the local authorities can choose not to have the public present, right? And that means that the newspaper won't be there. So they can say, we don't want the newspaper here, we don't want any of the public here. But if they do choose to have the public there, and therefore the newspaper can be present and report on it, then it's privileged, right? Except for malice. So the newspaper are always getting in, the newspaper turning up at the courts, the newspaper reporter's a dandy little fellow, isn't he? He's just popping up everywhere like a little mole, like, I can go where I want. I'm a newspaper reporter, unless the authority, where the authority has the power to impose a restriction. So local council can impose a restriction and not have the newspaper in there or anyone. Now, the newspaper might complain about that. The newspaper reporter might be complaining to the council, why aren't you having us in there, Well, that's a little bit like what the newspaper are doing to us, we choose not to have the petitions in there, but if they choose to have, everyone in there, they can't. They're not meant to have discrimination against, they can't say, we don't want Chinese people in this newspaper, we don't want Buddhist people in this newspaper. But now they're saying that, politicals, this is the thing. They're claiming that political issues, even though it's personal opinion, does it fall under protected characteristics or not? Well, it doesn't need to be protected characteristic because you can't hear it in a civil court or criminal court. So it's a protected characteristic to the fact that, it is a protected characteristic when you can't hear the fucking case in a court, right? That's a protected characteristic side of it, right? oh, we're in a court. This, is this a protected characteristic? Well, it's a protected characteristic when the court can't fucking hear it, right? That's protected, right? The court can't hear it. That's how protected it is of a characteristic, because it can't be heard in a civil or criminal court, right? That's how much of a protected characteristic it is. So, that'll solve Priti Patel's dilemma of her, locking on nonce stuff. Otherwise, a public hearing, or has the power to withhold information from the public during a public hearing. Well, I think the king, there's some weird arcane magic law with certain particular petitions which they can withhold from the public, right? To do with the Privy Council oath and certain things. But generally, if you haven't handed it in and you're still going around collecting signatures, they can't stop you from going collecting those signatures while you've still got it, and you're still, and that's the part that goes in the newspaper. And that's also the part that they can't really stop you from holding you to any commitments for. And then it's legally privileged. They're legally privileged items and information. Otherwise, public hearing or has the power to withhold information. Well, I think that with the petition, they don't have the power. Well, the newspaper doesn't have power to withhold the information for the power to withhold information from the public. Or has the power to withhold information from the public during a public hearing. Well, I don't think the newspaper has the power to withhold information from the public during a public hearing, because if it's like under the Public Meetings Act, it cannot prevent the transaction of information, right? If you're looking at the newspaper as, publishing, making it available to the public or a section of the public through any form and by any means, right? The court may so do on application by a party or on its own initiative, right? But, for a court, it's not meant, if it's Parliament, House of Commons, you're not meant to be in a court. The party who wants the restriction imposed must apply as soon as reasonably practical, notify any other party and any other person as the court directs. They must specify the proposed terms and how the restriction should last and what power the court should take. So, yeah, I mean, a newspaper, right, manager, chief executive, cannot ask a court to put a restriction on something on his own newspaper, can he? That's an interesting perspective, right? So let's say newspapers like owned by partnership, right? You got these lawyers like, Johnson and Smith or Baines and Biggins or, Polinsky and Rosowski or whatever it is, right? Let's say we've got a newspaper, right? Like Trinity Media Press or whatever. Let's say like it's a partnership, right? There's two owners who have got 50% shares each, right, in a newspaper, right? But they've got a chief executive and a art director and blah blah blah, whatever. They've got different departments, people, right? But let's say they have a dispute, right? And let's say someone wants to put a petition to the House of Commons in the newspaper, and one of the guys says, "No, I don't want it in there," and the other guy says, "Yeah, we'll have it in there," right? And then they go to court over it. Firstly, right, the court can't hear it because it's legally privileged items of information. Secondly, the court cannot put a restriction on the newspaper for one of those parties, for the party who doesn't want it in there. No, sorry, for the party who wants it in there. The party who wants it in there, right? Of the two partners who own the newspaper, right? The party who's happy with it going in there, right? If the party who's not happy with it going in his own newspaper, although he's in disagreement with his partner, right? you can't go to the judge, like, not like you could get into a court anyway because you can't hear it. But right, it would have been able to hear it in 1985, right, or 1984, but not in 1986 or 7, right? He can't ask the court to impose a reporting restriction on that petition. Do you get it, right? So, like, when courts are putting these restrictions on the newspaper, right, to say, like, you can't put this in the newspaper, like, the court can't do that because it can't impose a restriction. So if the court can't impose a restriction, get the newspaper to impose a restriction, then of the two partners, he won't be able to prevent his other partner, from doing it, like, not with enforceable court powers, not that it could be heard in the court, right? So that's really it. I mean, what, it's like Companies House. That newspaper can't, trade without Companies House. I guess it's a little bit like these. I think now thinking about it, it definitely is a little bit like this whole unions. When staff are going round, and apparently there's some law about unions. They're allowed to hand out the flyers and material, like,